the Senate Judiciary Committee will come to order. We have a couple of bills to hear today, and we are going to then work a couple of items we have previously heard. We don't yet have our reviser present to provide a bill brief, so we will stand at ease for just a few moments. Thank you. Thank you, committee. We are called back to order now, and we will open the hearing on HB 2516, requiring an offender who raises error in such offender's criminal history calculation for the first time on appeal to show prejudicial error, requiring the journal entry used to establish criminal history to be attached to the criminal history worksheet, and authorizing the court to correct an illegal sentence while a direct appeal is pending. So with that, then, we will ask the reviser, Mr. Thompson, for the bill brief. Thank you.
All right. Thank you, Madam Chairperson. House Bill 2516, as you mentioned, addresses some issues with an offender who raises error in their criminal history calculation. And we'll jump right into Section 1, which amends KSA 21-6813. That's the statute about pre-sentence investigation reports in our criminal code. There's a subsection B5 that is amended to provide that the journal entries for each listed prior conviction that is necessary to establish criminal history or to establish the application of a special sentencing rule must be attached to the criminal history worksheet and be a part of the criminal record. So that would be a new requirement that is not in the current law. The current law just requires that if any journal entries or other documents are obtained by a court services officer, they shall be attached to the pre-sentence investigation report. This would actually require those to be located, listed, and attached to the worksheet as part of the criminal record. Section 2 then amends KSA 21-6814. That's the statute in our criminal code about calculating criminal history, which, as you all remember, is the key to determining where you fall on the sentencing guidelines grid to determine what your sentence should be. The current law provides that the summary of the offender's criminal history prepared by the court shall satisfy the state's burden of proof regarding an offender's criminal history. The bill provides that the criminal history worksheet and the attached documents, instead of the summary, will satisfy the state's burden of proof going forward. There's also a new subsection D that is added to provide that if an offender raises a challenge to the offender's criminal history for the first time on appeal, the offender shall have the burden of designating a record that shows prejudicial error Otherwise, the claim shall be dismissed. In designating that record, the offender may provide the appellate court with journal entries of the challenged criminal history that were not originally attached to the criminal history worksheet, and the state may provide the appellate court with journal entries establishing a lack of prejudicial error. Finally, the court may take judicial notice of documentation when determining whether prejudicial error exists, and may even remand the case if there is a reasonable question as to whether prejudicial error exists. And then the last section of the bill is KSA 21-6820, and that again is part of our criminal code. And this is the section about departure sentences or rulings on certain motions being subject to appeal by the defendant or the state. The amendment here provides that a ruling on a motion to correct an illegal sentence pursuant to the criminal procedure statute KSA 22-3504 is subject to appeal by the defendant or the state. Under current law, the sentencing court retains authority for 90 days after entry of judgment of conviction to modify its judgment and sentence to correct errors. But the bill removes that 90-day limitation and provides the sentencing court retains authority to correct an illegal sentence or clerical error sort of in perpetuity. If a motion to correct an illegal sentence is filed while a direct appeal is pending, any change in law that occurs during the pending direct appeal shall apply. So we have a couple of appellate procedure issues addressed in that, in those amendments in that statute. I think that covers it. A lot of changes to the criminal code, some fairly technical ones, but I'd be happy to answer the questions that I can.
Thank you. Committee, any questions for the revisor? Seeing none, then we will invite our first proponent conferee. We're going to limit testimony today for all the conferees to 3 minutes. Your written testimony that you have provided is in its entirety within the committee record and within the committee members' folders and online. So with that, then I will give a 1 minute warning regarding when your 3 minutes is 1 minute left, and we will have Natalie Chalmers, Assistant Solicitor General, Office of the Attorney General. Please introduce yourself and welcome to committee. Push the button.
There, better. My name is Natalie Chalmers. I'm an Assistant Solicitor General in the Kansas Attorney General's Office. That is essentially a fancy way of saying I handle appeals. So I am an appellate attorney. The reason we brought forth this bill is essentially the Kansas Supreme Court in State v. Obregon opened up a floodgate of challenges to illegal sentences being raised for the first time on appeal. They since have largely shut the doors on that floodgate in Roberts and Corby. The bill, you'll hear from proponents and neutral and I think opponents that take issues with the requirement that the journal entries supporting the criminal history be attached. Our office is fine if you want to remove that language. We're good with that. The part that we want is the part that deals with how the appeal is handled, which is that it is the defendant's burden to prove that there is error by attaching things if they're going to raise something for the first time on appeal. And then the part that we really want is essentially, please go back to the district court. The district court is the better place for this. The district court can actually hear evidence and make factual findings, and in some cases can take judicial notice of its own files and kick this issue quickly. So it is, in our opinion, the defendant's and the state's best interest in most cases for the defendant to file a motion to correct an illegal sentence to raise these issues. So this bill allows them to do that even while their appeal is pending. Since I only have 3 minutes, I will be that brief, but if you have any questions, I would be happy to answer them.
Thank you, and we'll save committee questions till after we've heard from all the proponent conferees.
Thank you.
Thank you. Next, we will hear from Clayton Perkins, Kansas Association of Criminal Defense Lawyers. Please introduce yourself and welcome to committee.
Thank you. My name is Clayton Perkins. I am an appellate public defender, but I'm here today in my personal capacity and on behalf of the Kansas Association of Criminal Defense Lawyers. I'll take my 3 minutes to advocate for why I think this is a good bill, and we're proponents of all of it. It has sort of two aspects. The first aspect is Section 1, which is getting criminal history score accurate at the start, and Sections 2 and 3 are then fixing errors that are happening in criminal history. And why I think Section 1 is important is because the PSI is the fundamental backbone of our criminal sentencing process. We have a sentencing grid that uses both your criminal history score and the crime that you're convicted of to calculate the presumptive sentencing range in these cases. And that has a massive impact on sentencing. The biggest box difference between a B and a C on the grid is a difference of 314 months or 26 years in the sentence. So getting a sentence wrong has, one, a massive impact on the sentence itself, but then also a massive impact on things like the obligation the state has in paying for incarceration for, say, 26 years longer than it should. Or in tiny cases, the difference between being a presumptive probation case or a presumptive imprisonment case. So getting that right on the first end is very important. And the issue that we see over and over again in these cases is inaccuracies in the criminal history worksheet of the PSI, which is the starting point for our criminal history score calculations. The examples I have are diversions that shouldn't be counted as convictions that get counted as convictions. I have seen a case where the worksheet is supposed to list the convicting jurisdiction's statute for that conviction. I've seen many instances where it's a Missouri conviction or another state's conviction where it's listing the Kansas statute equivalent.
1 minute.
Thank you. Or I've even seen a case where it's police codes that are listed there instead of any statute. So the journal entries are the official court records of a conviction, and that's why we're asking for that, because that's the sort of basic appropriate document to work from. And the last thing I would add, or two last things, as the statute is already written right now, the PSI carries the state's burden to establish criminal history score. That's in 216813. And I provide a number of cases from the Kansas Supreme Court and even a Court of Appeals case from last Friday that all say the PSI by itself already carries the state's burden there. And the last thing is I'd point out a technical correction in Section 2 that I noticed. So in Section 2, the part on subsection B in there, it references KSA 216813C5, and that should have been B5, which goes back to the attaching of the journal entries. And I will stand for questions.
Thank you. Next, we have on WebEx, Aaron Breitenbach, Assistant District Attorney, 18th Judicial District, on behalf of the Kansas County and District Attorneys Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, and thank you to all for allowing me to testify today. I will keep my comments brief as I need to. Beginning with what was just shared regarding Section 1 and Section 2, the portions that an amendment is attempting to strike. I just want to point out that, yes, determining criminal history is very important, and the best time to do that is at the time of sentencing, and that provision would remain. In other words, if a defendant or his or her attorney want to object to anything in the PSI, do so. Please do it at the time of sentencing, before sentencing, so that we, the state, can provide journal entries to clear up the issue. We want to keep that process in place. With this statute, the two provisions that we're now seeking to strike this amendment, what they would add is a tremendous amount of time and resources to verify convictions that everyone in the room agrees to. And that's a waste of time, it's a waste of resources, it's an increase in cost, and this bill doesn't address who pays for that. Are they passed on to the defendant as court costs or restitution? Does the OJA or the justice, do they pay for it? Do prosecutors pay for it? When right now, everyone in the room knows, yeah, Joe was convicted of these 3 offenses across the street 2 months ago. We're done. There's no need to add all this. Now, if Joe wants to object and say, I wasn't convicted of those 3 things, then this statute and all prior statutes allow and encourage him to raise an objection at the district court level so that the state can bear its burden. The provision about the PSI meeting the state's burden is if there is no objection from the defense. So just to be clear, a defendant has the ability to raise an objection at the district court level, and this attempts to greater incentivize that, as opposed to waiting until the appellate level when the resources, the journal entries aren't there, and the Court of Appeals or Supreme Court is left with a difficult situation. So
1 minute remaining.
That's really all I have. The written testimony speaks for itself, and I appreciate the opportunity to support this bill with the amendment. Thank you very much.
Thank you. Are there any other proponent conferees in the committee meeting room or online? Seeing none, then, committee, we will open it up for questions for our proponent conferees. Oh, I'm sorry. Yes, please go ahead and approach the podium and introduce yourself, and welcome to committee.
Thank you, ma'am. My name is Ryan Duckers. I'm CSO 3 with Wyandotte County Adult Court Services in the Adult Probation Department. And I also serve as secretary of the Kansas Association of Court Services Officers. So I'm here on their behalf today to discuss House Bill 2516. Thank you for taking the time. As it's currently written, House Bill 2516 is an extremely important item of interest, not only to the over 300 CSOs across the state, but the criminal court system in Kansas as a whole. If passed in its current form, the requirement to have every single record of conviction attached to every pre-sentence report on all felony cases would have the effect of reversing progress that the CJ Reform Commission is attempting to address. This added requirement will result in defendants remaining in jail, awaiting sentencing, and receiving treatment for longer periods of time than they are used to. Most of the defendants that CSOs prepare pre-sentence reports for have at least one, if not more, prior criminal conviction. It is also fair to say that many defendants have years of criminal history records. Sorry, I'm not a great public speaker, folks. That would affect their criminal history score and sentencing per the guidelines. As written, the bill will dramatically increase this. Again, keeping defendants in custody longer than they should be. Costs would be affected, and length of time between plea and sentencing would be affected. We asked you to consider portions of the bill like Section 110F that indicates the court may take judicial notice in any subsequent felony proceeding of an earlier pre-sentence investigation report. We also point that Section 2A and C, which would lead a reasonable person to believe if working properly, any challenges to the criminal history would occur prior to sentencing. On behalf of the Kansas Association of Court Services Officers, I ask the committee to reconsider the amended language in the statute, and I thank you for your time.
Thank you. To clarify, you're a proponent, or are you testifying as a neutral on the bill, or you're a proponent with some amendments?
We would just ask amendments to the language regarding the requirement for the journal entry records of convictions. Yes,
Thank you. Thank you for clearing that up for our records. Appreciate that. Are there any other proponent conferees in the committee meeting room or online? Seeing none, then any questions for any of the proponents? Senator Haley.
Just to the last one, sir.
Sir, if you want to come back, Mr. Ducker.
Duckers.
Sure, if you want to come back to the podium.
Would there be some bullet points that you might provide by way of some written bullet points so we can have clarity for the various sections that you recommended, if that's possible?
If you'll re-identify yourself, please.
Ryan Duckers, CSO 3, Wyandotte County Adult Court Services. Clarification bullet points in regards to
Just some written, just something that we could.
So as far as cost of securing records, depending on if they're needing to be certified or not.
No, Mr. Duckers, I'm
Yes,
sorry.
sir.
Of your own testimony, that which you brought this morning, if there might be some.
Do you have a
one
written
where you had
copy
some
of your
written
testimony?
copies.
I think he's
No,
asking for.
we get some. Oh, okay. All right. Oh, you have one already? I didn't have one in my packet. Did you?
I did not. I think he just delivered it when he spoke today.
We have one. Thank you.
Does that suffice, sir?
It will. Thank you.
Thank you. Committee, other questions? Seeing none, then we have a neutral conferee, Amy Raymond, Chief of Trial Court Services, Office of Judicial Administration. Please introduce yourself and welcome to committee.
Good morning. I'm Amy Raymond. I'm the Chief of Trial Court Services for the Office of Judicial Administration, and I'm here as a neutral testimony on this bill. As you've heard, the PSI is a fundamental step in, excuse me, in the sentencing process. The CSOs currently first conduct a record check through the KBI. They use the information that they get from the KBI and the National Criminal Information System to track down and verify any convictions. They search court computers. They then use all of that information that they've gathered to assign the proper criminal history score to the current conviction. This proposed change to attach all the journal entries for each of the listed prior convictions could significantly delay the sentencing in the court process. It will increase the time a CSO spends on tracking down those journal entries, as well as potentially increase the time that a defendant is incarcerated, if not released on bond. While our Kansas records are fairly easily to obtain, there are significant challenges in getting out-of-state records. For instance, one of our CSOs recently tried to get records from California. California required the CSO to fill out 6 different forms for copies of these forms to be mailed to different agencies and individuals, and even included a personal service requirement on the defendant in jail. In Colorado, a CSO was required to file motions for juvenile court records, and so all of that process takes a significant amount of time. Additionally, if a state or municipality won't provide a journal entry to us, or a journal entry doesn't exist for a particular proceeding, there would be no way for the CSO to obtain that. And the currently the bill as drafted is silent as to what happens if we can't get a journal entry. So we do not want to take a position on the policy implications of this bill, but we just wanted to point out some of the hurdles that our CSOs would encounter and the potential increased cost and time in preparing our PSIs. And I'd happy to stand for questions when you're ready.
Thank you. Do we have any other neutral conferees in the committee meeting room or online? Seeing none, then we will open it up for any questions for our neutral conferee from the committee. Seeing none, then we will invite our first opponent conferee, Marissa Bayless, Deputy Special Counsel to the Chief Justice, Judicial Branch. Please introduce yourself and welcome to committee.
Hi, good morning, Madam Chair. Marissa Bayless, Deputy Special Counsel to the Chief Justice. As you can imagine, we're here just in opposition to that one portion of the bill regarding the attachment of journal entries. Our concern just arises because we believe this amendment shifts the state's burden of proof onto a neutral judicial branch employee, the court services officer. Under KSA 2168-14, the burden of proof is placed on the state to prove the offender's criminal history. Furthermore, under subsection C of the statute, the state has the burden of proving any disputed portion of the offender's criminal history. And we just believe this proposed change would move this to an inappropriate party in this instance. Current statute says that in the process of compiling the PSI report, should the CSO have documents or obtain a journal entry in that process, they shall attach. And so our proposed amendment that's attached to my testimony just reverts those sections back to current statute and have that process remain the same. I'd be happy to stand for questions at the appropriate time.
Thank you. Next, we will hear from opponent conferee, the Honorable Merlin Wheeler, Chief Judge, 5th Judicial District, on behalf of the Kansas District Judges Association. Please introduce yourself and welcome to committee.
Thank you, Senator Warren. I appreciate very much the opportunity to address this committee. We wish to specifically address the revisions to KSA 2168-13 subsection B5 that's contained in section 1 of the bill. We take no position or comment on other revisions contained in the bill that's suggested by our Attorney General's office. We believe those to be policy matters that are within the discretion of the legislature. Our reasons are set out in our written testimony. Foremost among those reasons is that the unavailability of copies of convictions in other jurisdictions will undoubtedly result in lesser sentences than would be warranted or called for under our Kansas Sentencing Guidelines Act. I don't think there's a judge in our association that would not be able to describe at least one circumstance of difficulty in obtaining, if not outright refusal, of other jurisdictions to respond to information requests. I'm most familiar with the problems from the state of California, but it's nearly universal. In fact, not more than about 10 minutes before this hearing started, I dealt with a situation from the state of Arkansas, where the state of Arkansas had failed to provide information to NCIS on a timely basis, which would have resulted in a significant change to a criminal history classification for a defendant that was ready for sentencing this morning. Not only that problem from other states, but some jurisdictions, such as municipalities in Kansas, do not do journal entries or record whether counsel was involved, and this has the potential impact of dramatically affecting the aggregation of person misdemeanors to a person felony under our Guidelines Act. In our KDJA committee meeting yesterday, we also discussed one other practice of defense counsel that's becoming apparent that this amendment would foster. We're aware that some defendants have taken the position that failure to challenge a criminal history classification suggested in a PSI report is malpractice, even if the defendant is aware of the prior convictions. This is done for a variety of reasons, including simply hoping for delay, as well as the hope that the prosecution cannot meet its burden to prove the criminal history. Just because copies are attached to a journal entry is not going to change that practice. Rather, it will probably foster that practice. The cost is increased delays, more hearings, and likely incorrect sentences. Delay will also, in our view, undoubtedly lead to increased pre-sentence incarceration times. The problem is most likely to arise with criminal history classifications that presume imprisonment, because those defendants are going to use delay as a means of hoping to avoid proof of a prior conviction. I'd like to conclude with 3 observations. Number 1, simply attaching a journal entry is not going to mean that there will be less challenges to a suggested criminal history classification. We think it will lead to more challenges because the defendant is going to routinely challenge, hoping that the prosecution cannot obtain admissible proof of prior convictions. Number 2, passage of this amendment will undoubtedly result in persons being sentenced incorrectly to lesser sentences and could result in some dangerous individuals being placed on probation, even though there may be more than an adequate reason to send that individual to prison. Our Sentencing Guidelines Act was designed to provide for truth in sentencing.
Judge, I hate to interrupt, but you were concluding and you are over 3 minutes, so I'll need you to wrap it up, please.
I will conclude with that, Senator Warren. I think I've expressed my opinions.
Okay, thank you. Appreciate that. And your written testimony is in its entirety, as are all the conferees, in the record online and in our committee folders. Thank you. With that, are there any opponent conferees in the committee meeting room or online who have not yet testified? Seeing none, then committee, any questions for our opponent conferees? Senator Haley.
No questions, Madam Chair. Just point of clarification as to Mr. Ducker's testimony. It is in our packet. He's not listed as an opponent, but it appears as if it was in opposition, the one that was presented earlier, just for clarity for the.
Thank you. And for the record, Mr. Duckers, if you could approach the podium one final time. You have submitted written testimony that indicates testimony in opposition of sections to House Bill 2516, and you stood up when I called for proponent conferees, and then you testified. And so for our complete records, we need you to identify, are you a proponent, an opponent, or a neutral conferee?
We remain neutral just to the bill itself.
Neutral. Okay, so this is written testimony in opposition, but with your identifying here today that it is neutral, then it will be placed online as neutral. So thank you for clarifying that. Committee, other questions for the opponent conferees? I have one question for either of the two. I don't see that there was any opposition testimony presented in the House. Is that the case? And if it is, why wasn't opposition testimony presented in the House committee? Please identify yourself. Go ahead, Judge. Please identify yourself.
This is Judge Wheeler again. Senator Warren, the bill was introduced in the House on January 20. It was set for hearing on February 1. 6 intervening working days occurred. We simply missed, when we were reviewing the bills that come across that may affect the judiciary, we simply missed this particular bill and simply did not have the opportunity to do so. And I think some of the testimony may have been classified as neutral testimony there that was perhaps in opposition to this one section.
Thank you. Did you want to say something, Ms. Bayless? Go ahead, identify yourself.
Marisa Bayless, Deputy Special Counsel to the Chief Justice. Yes, I believe OJA provided their neutral testimony for this bill in the House. Again, just kind of echoing to Wheeler's, we saw more of the administrative burden when we were reviewing this the first time as it was making its way through the process. We've came across what we thought would be a problem with shifting this burden.
Thank you. I do see that there was neutral testimony from the Office of Judicial Administration. There wasn't any opponent testimony at all on the House side. So our colleagues in the House have not heard this testimony before as we contemplate and work and discuss this bill here on the Senate side. Committee, other questions for any of our opponent conferees? Seeing none, then want to thank the conferees for their appearance and their testimony today. And we will then close the hearing on House Bill 2516 and open the hearing on Senate Bill 534, enacting the Reduce Armed Violence Act to increase the criminal penalties for certain violations of criminal possession of a weapon by a convicted felon that involve firearms. With that, we will ask for the bill brief from the reviser, Mr. Thompson. Thank you.
All right. Thank you again, Madam Chairperson. As you mentioned, Senate Bill 534 does enact the Reduce Armed Violence Act, and it increases some criminal penalties for certain violations of criminal possession of a weapon by a convicted felon that involve firearms. I forgot to note on the last bill that it passed the House 121-0. On this bill, I will note that it is identical to a House Bill 2657, which at this moment sits below the line, having passed out of the House Corrections and Juvenile Justice Committee, and it is exempt after it was referred to House Appropriations. So there's a mirror House version alive over in the House that made it out of committee but has not come above the line. So that's just for your reference. So the amendment to this bill is in KSA 216804, which of course is our sentencing guidelines grid for non-drug crimes. It's that long statute that has the grid in it on page 2 that you're hopefully very familiar with by now. And the only amendment is on the final couple pages to add a new subsection Z, which would be a special rule, like some of the other special sentencing rules that we have. The sentence for a violation of criminal possession of a weapon by a convicted felon would become presumptive imprisonment and would be served consecutively to any other term of imprisonment imposed if the trier of fact makes a finding beyond a reasonable doubt of two things. First, that the weapon the offender possessed during the violation was a firearm, and second, that such firearm was possessed by the offender during the commission of any violent felony. And then the key definition provided is of the term violent felony. There's a long list of those. I believe in testimony in the House and from the drafting of this, that this comes from the I want to say it's the felony murder provision, but the conferees can correct me if I'm mistaken in my recollection there. There's a similar list in another criminal statute. It's been modified in some ways to fit here. I think a few were taken out of that list. So hopefully the conferees can get into that and the rationale for including these particular crimes as violent felonies. And in the interest of time, I won't read the whole list, but you'll see there's a number of them listed there. Items capital A through capital AA on page 10 and 11. So that would be the new special sentencing provision that this would provide. And I'll be happy to answer questions.
Thank you. Committee, questions for the reviser? Seeing none, then we will have our first proponent conferee, Ms. Jessica Dome, Assistant Attorney General, Office of the Attorney General. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. My name is Jessica Domi, and I'm an Assistant Attorney General at the Kansas Attorney General's Office. I am currently assigned to the Criminal Litigation Division, and I have served as a prosecutor in the state of Kansas for 15 years. This piece of legislation was requested by the Attorney General after conversations with other prosecutors around the state, as well as law enforcement officers. Currently, if an individual is prohibited from carrying a firearm or a weapon, the crime for that is a severity level 8, which is generally going to be a presumptive probation offense. What we are seeing across the state is individuals see this as a slap on the wrist, and so they continue to perpetrate other crimes and other violent crimes. And so the Reduced Violent Crimes Act would require that a conviction for criminal possession of a firearm be served consecutive to any other crimes and be presumptive prison if a trier of fact finds 1, the violent felony occurred, and 2, a firearm was the weapon that was used in the perpetration of that violent felony. So that would require a special verdict form by a jury or a judge if the judge is the trier of fact. I would note, as referenced by the reviser, that this was a list of inherently dangerous felonies, which is what we're currently relying on for our felony murder statute. However, we went through that list and we removed a couple of those that didn't seem to fit. For instance, endangering the food supply was one of those, and so we just removed that. But we're not necessarily tied to this entire list if there's those the senators would like to remove. The House did pass this out of committee as proposed. In addition, we went in and added domestic violence offenses if they are felonies. So that is one that's not in the inherently dangerous felony statute, but domestic violence offenses committed that are felonies would be included in this provision. And with that, Madam Chair, I will stand for any questions at the appropriate time.
Thank you. Appreciate that. And I'm sorry I mispronounced your name.
Thank you.
Thank you. And next we will hear from Ed Klump, Legislative Liaison, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. My name is Ed Klump, and I am here representing the 3 associations the chair already listed. I appreciate the opportunity to speak on this bill. We strongly support this bill. As you know, violent crime is up across the country. Kansas has not been spared that. A lot of these crimes are firearms-related crimes. This bill cuts right to the meat of what a big part of this problem is. It's people that have committed other crimes. They are prohibited from possessing a firearm. They not only choose to possess a firearm anyway in violation of that law, but they choose to possess that firearm when they're committing another felony. I can think of no better way to use bed space than to get these kind of violent offenders, dangerous offenders, off the street. So one of the problems is that too many times our violent crimes involve persons who are violating these prohibitions. And too often, when they are convicted of these crimes, the penalty for the felony possession of a firearm is simply rolled in concurrently with the base crime. And so there is no penalty. They serve no additional time. I can tell you, I hear from law enforcement officers across the state all the time that one of the things that the armed felons ask them repeatedly is, am I going to be charged federally? And that's because federally they will serve additional time for these violations. Under the state law currently they do not. And so it is on the minds of these offenders. They are well aware when these provisions are in place. And we think this will have a positive impact on these violent crimes. And as such, we'd ask you to move this forward favorably. And I'll stay for questions when appropriate.
Thank you. Next, we will have retired Master Deputy Anthony Moe, President, and also Detective Jamie Miller, Region 1 Rep, Kansas Gang Investigators Association. So the two of you, you have 3 minutes each. So thank you, and please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. My name is Anthony Moe. I'm here representing the Kansas Gang Investigators Association. I've been a member of the Kansas Gang Investigators Association for 15 years and president for the last 7. As you said, I'm a retired master deputy with the Johnson County Sheriff's Office, where I served 25 years. Jamie Miller, he represents the 17 counties in the northeast section of the state, and he has been a detective with the Kansas City Police Department for 17 years. We're requesting your support of this legislation today because it fixes a gap we have with our current sentencing guidelines. Sentencing felons to probation only instead of prison time is not the deterrent needed to restore the safe streets that the citizens of the communities we serve in Kansas deserve. Law enforcement continues to combat gun violence in communities across our state. Career criminals are able to threaten violent acts using firearms and avoid prison time due to the current sentencing guidelines, even though our current law prohibits felons from possessing firearms. The number of repeat offenders is overwhelming. According to the statistics from the Wichita Police Department, the number of felons being arrested for firearm possessions doubled between 2015 and 2021. And to this year, they have exceeded 28 cases so far. There are numerous people in our state who make the conscious decision to continue to carry and use firearms to commit violent crimes, even after being arrested for violation multiple times. The need for a second chance for individuals who choose to steer their lives in the right direction is not lost to members of law enforcement. This law affects only career violent criminals.
1 minute.
Okay. It is a common knowledge amongst gang community that if they get caught, they get a slap on the wrist and more probation. Those individuals who choose to continue to commit crimes and cause violence have taken advantage of these laws. These career criminals will continue to use the system to continue to commit more violent crimes in our communities. As many of us are parents ourselves, we strive for our children to live in a safer society. As law enforcement professionals, we believe this is a significant step in helping to achieve those goals. Thank you for your time. We'll stay for questions.
Thank you.
Yes, my name is Jamie Miller. I'm a detective with the Kansas City, Kansas Police Department. The only thing I'd really like to add to Tony's, what he had to say is that we, as gang investigators, we often deal with, I've been doing this for almost 7 years now, and we deal with these young people as they grow up and become involved in gangs and criminal activity, and removing firearms from people who continue to do that, to carry firearms, even though they know they're prohibited from doing so, will seriously help prevent younger people from beginning to carry firearms because they won't feel like they have to as much. A small percentage of even gang members are actively seeking violence, are actively going out there looking to commit harm to others. If the kids that aren't quite involved yet don't feel the need to carry a gun because these career criminals are in prison for carrying firearms, or they don't carry firearms because they know the consequences of that might prevent future young people from getting involved with gangs or criminal activity. That's all I have. I'll be around for questions if you have any. Thank you.
Thank you. Are there any other proponent conferees in the committee meeting room or online? Seeing none then. Committee, any questions for our proponent conferees? Senator Gossage.
Thank you, Madam Chair. Could the gentlemen come back up that were just here?
Yes, ma'am.
Thank you for coming. We just read that the Olathe East shooter used a ghost gun.
Yes, ma'am.
Does any of this affect that?
Please identify yourself before answering. Thank you.
I apologize. Jamie Miller, detective with Kansas City, Kansas. I don't think that it identifies the difference between a firearm and a ghost gun. A ghost gun is, for all essential purposes, a firearm. The only area where I know it comes into effect is in federal. That you can't prove interstate commerce when you have a ghost gun because you can't prove that it was manufactured in a state outside the state you're in. So the fact that he was in possession of a ghost gun does not affect anything that he'll have to go through and involved in that.
So it would be the same whether it was a retraceable or an untraceable gun, or a gun that you could trace, as far as what you're recommending for sentencing.
I'm sorry, I didn't hear the first part of your question.
So whether the gun was considered an untraceable or ghost gun, or another gun that you can that has the identification on it, the sentencing would be the same as to what you're recommending.
Correct. From my understanding of the bill, yes, whether the firearm has a serial number or not would not affect the sentencing.
Thank you. Thank you, Madam Chair.
Senator Haley.
Thank you, Madam Chair. And to Senator Gossage's point, I believe in the instant case regarding the tragedy in Olathe, this would only apply for someone who's already had a previous conviction and is a felon. So I don't know if the shooter in this particular case has that previous history or was a felon, but this would be then only applied if that's the case.
Yes, sir.
Please identify yourself again. Thank you.
Jamie Miller with Kansas City, Kansas. I apologize. I don't know the specifics on the incident in Olathe East, but just from the generalization of what I've heard, if he were to have had previous convictions of felony crimes, yeah, that would come into play in the sentencing for the crime that he committed and the being in possession of a firearm.
Thank you. And Madam Chair, I don't know if Jessica told me if she wanted to, if I might.
Please identify yourself.
Jessica Domi with the Kansas Attorney General's Office. Thank you, Senator Haley. Yes, to the previous senator's question, this would apply to any type of firearm if they were previously prohibited. And then to Senator Haley's point, it's not just a conviction, but also an adjudication as a juvenile, which would qualify under the criminal possession of a firearm or weapon by a convicted felon charge. So my understanding is in Olathe East, he was previously adjudicated with a person felony and was prohibited from carrying a firearm. So this would apply to such a situation. Thank you.
Thank you. And Madam Chair, if you indulge us, if Ms. Domi, Jessica, if you would, we serve on the Sentencing Commission together. She's one of our leaders there. Good to see you here in person. We've been on Zoom all this time. This is, and I'm trying to wrap my head around this. This is a possession crime. I mean, or would one have to actively have? I remember we talked about the tier with the AG actually of possession, brandishing, and actual discharge. This is a mere possession, and not if the weapon or the firearm were brandished or used, just if it's on the felon's person. Or is there would there have to be some active involvement with the weapon in the commission of the subsequent felony for this to apply? Or it's just that they had it in their car or had it within their possession that would trigger the consecutive sentence? You understand what I'm asking?
I do, thank you, yes. The language of the statute or the bill, the way it is drafted, is that the trier of fact would have to find that they possessed the firearm in the commission of a violent felony. So the trier would find whether they possessed it in the commission of that crime, meaning it couldn't have been in a car and they were off doing something else potentially, unless the trier of fact found that it being in their car while they went in and robbed the bank without the gun was possession, if that makes sense, Senator. So they have to have a finding beyond a reasonable doubt that they possessed it, and they possessed it while they were committing a violent felony. Does that make sense?
It does, and I won't get into the weeds on this, but if someone does not brandish, if they have on the, I don't know, think of a robbery or something, and they can see the gun on the hip or whatever, but it's not brandished or held. I mean, would the victim have to have been aware of the weapon to bring about that it's being possessed by this bad actor, this felon, in order for this to be triggered?
The trier of fact would have to be evidence presented to the trier of fact that the offender possessed the gun. So if the prosecutor was able to show through photographs and other items that the offender had a gun on his hip as he was robbing the bank, an armed robbery or something to that effect, I think that would be sufficient evidence for a trier of fact, and then the trier of fact would have to determine whether that was proof beyond a reasonable doubt. There's no requirement that a victim has to have seen the gun, because that would be probably some other elements of the offense. It's just that the trier of fact found that they possessed it and that they did so in the commission of a violent felony.
Thank you so much.
Thank you.
Committee, other questions? Seeing none, then committee, you have in your committee folder and online proponent written only testimony from Greg Smith, Special Deputy Sheriff for Government, Veteran and Crime Victim Affairs, Johnson County Sheriff's Office, from Michael F. Kage, District Attorney, 3rd Judicial District, Office of the District Attorney, Geraldine Wheelies, Police Officer on behalf of the Kansas State Lodge Fraternal Order of Police, Brian Wheelies, Chief of Police, Topeka Police Department. We don't yet have paper copies from Mr. Wheelies. And we also have, which is going to be distributed, written testimony from Stephen Howe. Well, I don't have a title, but Stephen Howe, who is the District Attorney in Johnson County. And we will distribute these then. And any neutral conferees in the committee meeting room or online. Seeing none, then we will hear from our opponent conferee on WebEx, Nicholas Reinecker, private citizen. Please identify yourself and welcome to committee.
Thank you, Madam Chair and committee. Can you hear me okay?
Yes, we can.
My name is Nick Reinecker, Inman, Kansas, private citizen. I'm here today to be an opponent on a very narrow scope for this bill. It starts in subsection Z3U involving unlawful 215705 and 215706, the unlawful cultivation or distribution of controlled substances, specifically cannabis, and the unlawful possession of controlled substances, specifically cannabis. I would like to let the committee know that I am for mandatory minimum sentences. Any individuals who are dealing methamphetamine while armed should receive some sort of mandatory minimum sentence. I would be okay with. I put a scenario there that it maybe have some technical holes in it, but you can check it out there and read it for yourself. I don't have time necessarily to read it all, but I'm okay with all the list of the violent felonies. It is a good thing. But when the government started outlawing natural occurring substances, I believe it planted the seeds of socialism by taking away liberty from the individual and perverting it into corporate enterprises that monopolize the synthetic properties of outlawed plants. Now, we as a society have been trained to respond a certain way to words. Say marijuana, and people generally think of a thug on the street doing violence with a firearm. Say cannabis, and it's not so startling. Say someone has COVID-19, and we've been trained to think that's fear, death, everything. Say I have a cold, whatever. Maybe we should revisit the definition of terrorism. The reason I keep doing this over and over again is because I am not only on a mission to deschedule cannabis, but I believe that if we are honest with ourselves and take into account the bully spirit that sometimes infects processes under the dome up there, we know cannabis is supported by a lot of people, but because of that bully spirit, those who I believe, as I do, are silent on the issue. And being silent on issues of liberty is the reason we're in some of the mess we're in. When chairmanships and being part of the cool kids is more important than defending the Constitution, even the issues you may not like, we will continue to see.
1 minute. 1 minute remaining.
We will continue to see people being abused, neglected, and exploited by the government and crony capitalists. We have been on and on about states' rights and reasonableness, and again, that is why we have a State-Controlled Substances Act. And just like listening to the CDC and not the individual, you are listening to other entities and not individuals like myself. You have the scenario. If you want me to go over the scenario, I could do that. But other than that, I'm a proponent of the bill, except for the fact that however you get to a felony possession of cannabis and then maybe do that down the road. And it also takes up with the laws of prohibited persons anyway. But that's a discussion for another day. Sorry for the entire business to attend to, and I thank you for your time, and I will stand for any questions, Madam Chair.
Thank you. Do we have any other opponent conferees in the committee meeting room or online? Seeing none, then committee, any questions for the opponent conferee? Senator Haley.
Well, Madam Chair, I really appreciate Mr. Reineker's observation. I too have had some concerns over the over-criminalization, especially of what is still illegal in our state regarding cannabis, but in surrounding states is not. So is it possible that I might redirect to a previous conferee in light of the testimony Mr. Reineker brought? It would be to Jessica Domi, or if
Thank you for the question, Senator. It's our practice that once we've moved from a category of folks, we're not looking back.
Mr. Reineker, if I could, and any others who might be listening and might opine later, if this section, a previous conferee, Nick Reineker, indicated that there had been some provisions that were relatively benign that were moved out of the bill before, that they were removed. I don't remember what those were, but she did list them. They might be in her testimony. If this provision were taken out, and if I read it correctly, it's lines 21 and 22 on page 11 that talks to 21.5.705, 21.5.706. If those are only related to cannabis, would you then withdraw your opposition to the bill, and would the remaining sections still be enforced by felons who subsequently possess a weapon in the commission? Mr. Reineker and anyone else who cares to weigh in.
Mr. Reineker, please go ahead and identify yourself if you can answer the question.
Madam Chair, Senator Haley, Nick Reineker, private citizen, Inman, Kansas. Absolutely, sir.
Thank you, sir.
Thank you. Committee, any other questions for our opponent conferee? Seeing none, then we will close the hearing on Senate Bill 534. And we are going to work a couple of proposed constitutional amendments, committee. We are short on time, running out of days in committee, and we need to get some measures to the Senate as a whole, if that's the will of the committee. And we will first look at, I don't recall the HCR number, but the one regarding rules and regulations that came over to the House, came over from the House. That's HCR 5014. HCR 5014. And we will have just a short bill brief from the reviser. Thank you.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. As you may recall, HCR 5014 is a mirror version of SCR 1618 that you also heard in this committee. Looks like we had the hearing in here. Well, I don't have the exact date in front of me, but we had it recently. This is the HCR that would add a provision to the Constitution to be placed on the ballot in November of 2022. that would authorize legislative oversight of administrative rules and regulations. Just very, very briefly, the current law gives the legislature authority to review rules and regs through its Joint Committee on Administrative Rules and Regulations, but no power to alter or amend those regulations or reject those regulations, only act through legislation in response to those proposed rules and regulations. And this would have a new section 17 in Article 1 of our Constitution that would authorize the legislature to have authority to revoke or suspend rules and regulations through a procedure that they would be able to adopt subsequent to the enactment of this, if the people were to enact it. And I'll be happy to answer questions.
Thank you, committee. We did hear this March 2nd, and it did pass out of the House. I apologize if I'm repeating, but it did pass out of the House 85 to 39. So with that, committee, any discussion or motion on the resolution? Senator Thompson.
I'm not sure if this is appropriate motion or not, but I would move to pass out House Concurrent Resolution 5014 favorably.
Thank you, Senator. Mr. Revisor, that is a proper timely motion at this time? It is, yes, so I agree. Committee, do we have a second? Senator Gossage with the second. Thank you. I'm sorry, I didn't look to the right quickly enough. Committee, you have heard the motion. Any discussion on the motion? Senator Corson.
Thank you, Madam Chair. I'm going to be opposing this. I worry that we're opening up a real Pandora's box with separation of powers and having the legislative branch now interfering with rules and regulations issued by the executive branch. If you think about the number of executive branch agencies we have and the idea that we would possibly be taking a look at every single regulation and deciding whether or not we like it, asking for regulations to be rewritten and redrafted again. I'm just very concerned about the practical aspects of this and how this would work in implementation. Obviously, I understand the I think, broad intent behind this, and I'm not completely unsympathetic to that, having served as I do with the chair on the Joint Committee on Administrative Rules and Regulations. Obviously, I think we all share some frustrations at times with that process, but I do worry that we're opening up a real situation of legislative micromanagement of the executive branch in a way that I think we'll find in years to come has a lot of unintended consequences and really stops our government from being nimble and efficient. So I won't be supporting the motion, and I appreciate it, Madam Chair.
Thank you. Committee, other discussion on the motion? Yes, Senator Thompson.
Thank you. And I understand Senator Corson's point. However, I think that, we've seen over the last 2 years a situation that we couldn't have imagined before. And speaking to being able to be nimble on situations, perhaps, business closures, overreach and things of that nature, I don't think that this legislature or any legislature in the future is going to want to dive in to every single executive order. But I think that in a situation where we do need that sort of thing addressed, this gives us the opportunity to do so. And I think, if anything, the last 2 years have shown us that is a definite need, and this is a reaction to a lot of public sentiment. So, in my opinion, let's let the public decide and give them the voice. And I appreciate it very much. Thank you, Madam Chair.
Thank you. Committee, further discussion? Seeing none, then, you all have heard the motion. Those in favor signify by saying aye. Aye. Those opposed, no. No. The motion carries. Yes. Yes. Senator Haley would like his no vote recorded. Thank you. Committee, then, we will turn now to working. Senator Corson would like his no vote recorded as well. Committee, then, we will turn to working SCR 1621, which is the first of two proposed constitutional amendments regarding judicial selection of our Kansas Supreme Court justices. So with that, we will ask for a short bill brief from the revisor.
Thank you again, Madam Chairperson. Jason Thompson, Revisor's Office. SCR 1621 is the amendment proposed for the August election to coincide with the primary election that would amend two sections of Article 3 of the Constitution to authorize selection of Supreme Court justices by the governor with confirmation by the Senate, and would abolish the nominating commission. I'd be happy to answer questions.
Thank you. Committee, questions for the revisor. Senator Pyle.
Thank you, Madam Chair. I had asked research to get some information as to the history of the tenure of judges and the length of time that they had served. I don't think anybody has presented, but this amendment was offered in 2013. Did we have that in, was that, Jason, did you share that in review that it passed the Senate in 2013? It was, I think, authored by Senator King at the time.
Madam Chair, Jason Thompson. I did not have a note on that, but I will look back real quick and see if I can find it.
I believe it was SCR 1601 in 2013.
Sure, Mr. Gallimore.
Thank you, Madam Chair. And to the Senator's question regarding the research, my colleague Natalie Nelson has been working on that. She was unexpectedly had to be out of office today. She indicated she anticipated completing that research tomorrow.
And Mr. Gallimore with the Kansas Legislative Research Department. Thank you.
Well, Madam Chair, I was waiting on that research for the purpose of drafting an amendment. So you brought this up when I appeared. I mean, you just had the hearings. Was it Friday? I think I WebExed in and listened in on that. A lot of lengthy, good, long meeting. I mean, it went till like 1:15, I believe. So, but I would like to have an amendment for this, but I can't prepare that without that information from research. So, just something to consider. If the committee wants to go ahead and pass it out, pass it out. I'll have to bring an amendment on the floor then. Thank you.
Committee, other discussion on the resolution. Senator Haley.
Well, thank you, Madam Chair. I did not know this was going to be worked today. I know we had some other bills to be heard. I wasn't here when you said those were going to be struck and heard another day. The House Bill 2607 and 2050-74 were not going to be heard today. Despite the abolition of the option of a nominating commission to assist, what else troubles me largely is the date being called 3 months, 4 months, I guess, from now, well, 5 months, in August of this year. I really think that it's, well, it's not moot, especially with the other items that will be on the primary ballot of this year, of which we're all aware, and the not ability to not educate fully the electorate or voters as to what a quantum change this would bring from what we have done from the time that we have direct appointments that are not vetted through neutral, non-political sources, which of course is what the passage of this resolution will return us to. There was discussion of the triple play. There was representation from the proponents that we can't go back to that dark day in Kansas history and that trilogy. But I'm not mollified personally that that would not be the case. I do believe we should have a commission retained in place that's as independent as possible to vet and to be allowed to look at the best possible jurists that will be there on our bench, and to dilute that for political reasons, which is what this is about, is I think a disservice to the quality or more quality system that we have in place. That having been said, my amendment that I would like to offer would change to 2024, the primary in 2024, to be considered, or at least sometime. 2024 is a long way away, but of course, you know, the primaries will be then for certainly for these seats where we sat in the Senate, and a host of other offices. And it would give an opportunity to fully evaluate what it would mean to change from 60 plus years of a system that has provided more equity and apolitical appointments and considerations of judges. So in sum, I'm very disturbed that in 5 months, we'll be asking Kansans to weigh in on something that they haven't really been able to fully evaluate and the change that it would bring. And I would like for us to reflect on another date or another time with which to hold that election. Thank you, Madam Chair.
Thank you. The proponents of the concurrent resolution before us, the proponents who were suggesting a change to the selection of Supreme Court justices in Kansas, have no qualms about the time frame that the proposed amendment proposes, quite frankly, to be on the ballot. It was the opponents who seek to keep the status quo. The status quo is something that all Kansans have had opportunity to know about. It's been the status quo. So there's nothing to educate them about on the status quo, and it would be the proponents then who would be educating on a proposed change, and the proponents have no objection or no issue with putting it on the August 2022 ballot. So just want to remind the committee of the testimony that we heard, that the proponents are bringing us the draft of their proposed amendment and with the date as set forth, and it's those who want to keep the status quo who are objecting that the time is too short. So with that, any other discussion? Senator Corson.
Thank you, Madam Chair. I would like to make a motion to table this. And the reason is, I know that we did have a lengthy hearing on Friday, but we really had one day with a couple days notice given to proponents and opponents. And but my main qualm is not with the hearing. It was lengthy and folks were able to provide testimony, but this is a major change this is not a law. This would be, if the voters adopted it, a change to our state constitution. And I really think that we should, maybe have an interim committee and do some serious work at what are other models in other states. Many states have hybrid models where they have a nominating commission with Senate confirmation. I mean, there are a lot of ways to do this that I don't think we've even really scratched the surface of looking at. And I think without the nominating commission, we really lose a lot of the transparency that we have. I mean, if you think about the nominating commission, the openings are publicly posted, the application is publicly posted, some of the applicants' responses are publicly posted. We know who applied for these. The interviews are open meetings. The nominating commission is subject to the Kansas Open Records Act. We know the questions that were asked. We know the responses that were given. And we would lose all of that by doing away with the nominating commission entirely. You would have a situation where a governor would make a selection. We wouldn't know who else was considered. We wouldn't know why that person was picked. We wouldn't know any of the questions that the governor may have asked that person. So I would just like us to see us do further study about what could be other models, what are other states doing before we leap to doing this after having one hearing. So with that, I'd like to make a motion to table this. Thank you, Madam Chair.
Thank you. Committee, is there a second? Second, we have a second. Committee, discussion on the motion. Yes, Senator Gossage.
Madam Chair, the majority of the constituents that have spoken to me about this issue, or it's been brought up in a forum, were actually shocked that this is how we do our election. This is how we do the nomination for the Supreme Court. These may be held open to the public, but I wonder how many people in the public actually know that this is going on or that they can see. I'm sure that there are some attorneys that are aware. As far as them being vetted, or they can look at the application, et cetera. I think that this could still be something that would be done. I can't imagine that we look at the federal court, the federal Supreme Court, and how the president then selects a nomination and it's brought forward. I'm sure this just didn't pop to their head, hey, I like Joe over here who's an attorney. These people have to be vetted. They have to come in with credentials, have to have a background check, etc. And I cannot imagine any governor with either party that would not look to the Attorneys Association for recommendations or others. And so I honestly can tell you that I don't know anyone that has said, I'm trying to think, was there anyone who ever said to me, I think that this is a good idea how we do it right now. They would like to see this, do it in such a way that the Senate does and can weigh in on the nomination, and also the fact that the governor is held to just 3 that were selected by a specific group that said you can only choose from these 3. It's just unconscionable to most people. So I don't think we need to table this. I think we have a really clear idea. We have proponents that have brought this forward, and I would not be in favor of this motion.
Thank you. Yes, Senator Thompson.
Thank you, Madam Chair. And just to dovetail with that, I think you could study this thing to death and end up in the exact same position as we are now. We heard fairly robust testimony. We heard the proponents talk about how, for lack of a better term, that the way things are done right now is almost an echo chamber. And so I think it's time to move on this. This has been discussed very, very well. And like I said, we could tread water for another year or 2 on this and end up in the same location. So I think that we should not table the motion or table the discussion. Thank you.
Thank you. Yes, Senator Corson.
Thank you, Madam Chair. One example I want to give of what I think we would lose with the nominating commission from our very recent history is, if you think about somebody like Justice Stegall, who I think is a brilliant jurist and has served us with real distinction, if you think about his background and a lot of the questions that he faced, I think that had he just been selected because of given his previous experience and connection to Governor Brownback, had he just been selected by Governor Brownback, and nobody would have known anything about, what their conversations were, or they just would have known his very close relationship and association with the governor, I think that nomination would have had a lot of trouble moving forward, both in public perception because of their close relationship and with this body. But because Justice Stegall came through a nominating commission process where he was vetted, he was one of the 3 names that were given to Governor Brownback. Folks were able to see his application. They were able to see his interview with the nominating commission. I think it gave that nomination much more credibility in the minds of the legislature and in the public because he came through that. And I think if we got rid of the nominating commission, we would lose in the future folks like Justice Stegall, because the process would be so much less transparent and so much more closed door that I think the nominating commission gave Governor Brownback a ability to credibly make that nomination. And again, I think he's served us well, and that's an example that we would lose by doing away with this. Thank you.
Committee, you all have heard the motion we will have one more item of discussion on the motion to table. Go ahead, Senator Pyle.
I just think that I'd like to know, based on those comments, when Justice Stegall was nominated, what year? Was that at the same time that 2013-14 period, while this amendment was passed by the Senate and held in the House chamber for 2 sessions? Was that there? Could the reviser, does he know when Justice Stegall was nominated and made it through the nominating procedures? Because it seems, Madam Chair, to me that these amendments come up, and I'm for reform. Don't get me wrong. I've proposed plenty of opportunities to change the Constitution on this issue with judicial reform. Do you have an answer, Jason?
Go ahead, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. We were just conferring here at the staff table to make sure I had it right. So the appointment to the Court of Appeals was 2013, which was when the resolution was pending. And then the appointment to the Supreme Court of the same justice, then to become justice, was in 2014. And just based on the timing, the resolution by that point had passed the Senate, but was pending in the House when, actually, no, in August of 2014, when the appointment to the Supreme Court occurred, the legislature would have been out of session by then. So 2013 lines up, but 2014 then is right after the session was over.
And was I correct that 1601 died in the House Judiciary?
Mr. Thompson.
Madam Chair, Jason Thompson again. Yes, so you asked us earlier to look that up. SCR 1601 in session 2013-2014 did pass the Senate 28-12 and then died in House committee after a session ended in 2014.
Thank you. And as to the motion to tabling, I'm kind of a little bit kind of like support this just for the sake that we could pull it off the table and have an opportunity to amend it at a later date, because I would like to amend this here in committee rather than on the floor. But I also have to point out too that the prior amendment, very, very much the same thing, died in the House. And it appears could have been potentially just political posturing. Because we all know the makeup of this nominating commission. And we know the makeup back then, what it was. And there were a lot of reports in the news and everywhere that how a conservative made it through and was nominated for the Supreme Court. The question before us today to table, we must also ask our question, what is before the courts today that's bringing about this action by the Senate President? And this action in this committee? And is the question here to table relevant in the fact that maybe we should put some demands on the House that they run this and vote on it before we do this time, because we did it last time? Madam Chair, I don't know how I'm going to vote on this motion yet. I'm still trying to figure that out. I think it's a relevant motion. I like the idea of being able to amend this in committee. I mean, it'd been nice if we'd have known, this was coming up. But we didn't have that luxury. So anyway, I have some concerns with the motives behind why this is being pushed and as to whether it actually could get to the ballot. I would love to see it get to the ballot, but I don't really think that's going to happen, Madam Chair. I'm very questioning at this point. Thank you.
Thank you, committee. We did hear testimony that this has been a proposal at least since 2005. It's been around the Capitol for quite some time, more than a decade. And we have on our agenda for today possible final action on bills previously heard, just like we do all days. So it is properly noticed to proceed today. Committee, you have heard the motion. The motion is to table SCR 1614. All those in favor? I'm sorry. Let me state that again. Committee, you have heard the motion. The motion is to table SCR 1621. All those in favor signify by saying aye.
Aye.
All those opposed signify by saying no. The motion fails. We are back on the motion to pass out the SCR. We have a request for division. So all those in favor of the motion to table SCR 1621 signify by raising your hand. Seeing two hands. All those opposed to tabling SCR 1621, raise your hand. Seeing six hands, the motion fails. We are back on the motion to pass SCR 1621 favorably.
Haven't got a motion.
There was a motion, and then there was a motion to table. We had a motion from Senator Thompson and the motion that was seconded by Senator Gossage. Then we had a motion to table. So are we back on the original motion or we're not?
Madam Chair, Jason Thompson, Revisor's Office. Sorry for the confusion. At least here at the staff table, we had that prior motion on HCR 5014, but no prior motion on SCR 1621. You just went straight to the motion to table. So now you're back on working the SCR with no motion currently pending. That's our recollection.
Wonderful. Thank you then. Senator Pyle.
There seems to be a little bit of confusion, and I would really like to delay working this until I get the research and my amendment to offer. So with that, I'm going to make a motion to adjourn the committee, Madam Chair.
Only the chair of the committee can adjourn the meeting, so that motion is out of order. Committee, do we have a motion on SCR 1621? Senator Thompson.
I would I think that maybe perhaps it might not be a bad idea to pass over this right now and go on to the next one until the research has a chance to provide some information, and then we could vote on any potential amendment.
Committee, we are waiting on research regarding, I think we had that question answered. I'm not sure what research we're any longer waiting on. But if Senator Pyle wants to clarify that.
I'm not sure the research person here in front of me, the gray coat, what his name is.
Mr. Gallimore.
Mr. Gallimore stated that Natalie is trying to get that research prepared by tomorrow. And so when I get that research, then I can formulate. I need that research to formulate my amendment for this. I can't do the amendment till I have the research. So it'll be based upon when Natalie returns and has that research, Madam Chair.
Committee, again, it is always noticed on our agenda, possible final action on bills previously heard. So it is in order to go ahead and work the SCR just like any other bill that we have previously heard. We are hearing that we will have some additional information from research tomorrow. We are going to then suspend our work on SCR 1621 and stand at ease for just a moment.
I'm glad you said that.
Good time. Because then we can have.
You flipped through that in utilities.
I didn't. I've dealt with that. Yeah.
I'm not going to do that.
What's that?
Committee, thank you for standing at ease for a moment. We know that our research, Ms. Nelson does diligent work, and we are expecting her research to be provided to committee on this SCR 1621 tomorrow, so we will address that tomorrow. So committee, be prepared to work SCR 1621 tomorrow. And if there are any proposed amendments, have them in writing. And we will then be working SCR 1621 and SCR 1622 tomorrow. Is that the 1621 and 1622 tomorrow? So with that, committee,
Madam Chair, and just asking for the status of the remainder bills that were on today's agenda, House Bill 2607 and 2574. Will they be scheduled for some later time?
I was about to get to that.
Okay, I'm sorry. Thank you.
Thank you. Committee, regarding House Bill 2607 and House Bill 2574, do apologize that we were not able to address those today. I know there were conferees in the committee meeting room, and again, apologize that we weren't able to address those today. Would welcome the conferees back on House Bill 2607 and House Bill 2574 at a different date. We do not have that scheduled yet. Committee, we have few days left. We do have committee scheduled for this Friday, March 11th, for possible final action on bills previously heard. Please watch the agenda. We may set some bill hearings that day as well. So we do want to take a look at the policy in HB 2607 and HB 2574 as best we can with the time remaining. So watch your emails, please, and notices for revised agendas. And with that, then, committee, we are adjourned.